be that the driver's negligent and the passenger suing the driver for the negligence.
Right.
Which case?
Well, as a passenger, you're always entitled to recover if you're injured.
Yeah, you have a standard of care there.
As long as you didn't contribute to the accident, which usually, how does a passenger do that? The law school story was the passenger who put his or her hands over the driver's eyes. You know, there's some contributory negligence.
Yeah, yeah.
But for the most part, they're an innocent person in the accident, so they can recover against either the driver or the other party if they're at fault.
Have we covered that topic, or do we need to discuss more about the extent of the insurance coverage that someone needs?
I think we mostly talked about it as it relates to automobiles, but with homeowner policies, there's not that much of a difference, but I think you should still at the same have uninsured coverage or an
umbrella policies.
An umbrella
Again, those are fairly inexpensive.
Yeah. And at what point does someone need to address having an umbrella, a larger umbrella? How do you know when you actually need one?
It depends on what you have for assets that would be at risk. Obviously, with your homeowner's insurance, you'll have some liability coverage, but it's not extensive. If you have extensive assets and you injure somebody, they can be at risk. An umbrella policy will cover you for both your auto accident and someone who's injured on your property.
Yes, and of course we're not trying to put you in a place of being an insurance agent here, but the broad brushstrokes of it.
My understanding is in order to recover from the umbrella policy, you have to recover all of the, you have to exhaust the limits on your regular policy.
Right, the underlying liabilities. If it's automobile, that policy. If it's an injury at a house, that policy.
Well, I think it's maybe time that we start to broach the subject. We're talking of so many torts to cover. I don't know, as many weeks as we will ever do the show. Thinking about medical malpractice, there's no more contentious issue that we've ever heard of than needing tort reform because of, to put a limit on the amount of medical malpractice. Why don't you go over that, at least in broad brushstrokes for this session? I'm sure we're going to need to cover it more extensively in the next.
Well, let's see what we can do. Medical malpractice is another form of negligence. It's sometimes called medical negligence. And in any negligence case, you look at the person who's committed the tort, the negligence. In the case of a doctor, you take your doctor as an ordinary, reasonable, prudent doctor with the same training, and what would that person do in the same situation? And if the doctor dips below the standard of care, then he can be responsible for the injuries he caused. There's a lot of information out there about tort reform, and if you look at any of it with the medical area, you'll find that medical insurance, medical negligence, liability insurance, and those claims amount for a tiny fraction of the total cost of health care in the United States.
Is that true?
It's absolutely true. And what you hear from people who are proponents of that is that, you know, doctors have to go out of business because of how expensive medical malpractice is and all of that. But if their family member was the one who was severely injured by a doctor who was clearly negligent, those will be the last people who tell you they're all in favor of tort reform for medical malpractice. Medical malpractice claims are very difficult. Very few lawyers will take them unless, because of the expense, unless the damages are significant.
Or obvious? Or does that not matter?
Even obvious is not necessarily going to lead to a lawyer taking a case if the injuries aren't significant because of the costs. And you want to explain some of that?
Typically when an attorney who specializes in medical malpractice takes a case, they want to get the medical records. They want to send it to one of their own experts. And that's where the cost lies, because one of their own experts could charge anywhere from $3,000 to $5,000 to maybe even $6,000 or $7,000 just to review the case.
Just for the review.
Just for the review. And that is something that the law firm itself has to out-of-pocket. And it becomes increasingly expensive, especially if you're going to take a case to trial. You've got to hire experts. If you have your own expert, this expert, assuming it's a physician, they want to be paid for their time. If they're out of their office for a particular amount of time during the day, they want to be paid for that. That all adds into the cost.
A medical malpractice case going to trial is going to cost thousands, tens of thousands to hundreds of thousands of dollars to try. So if the damages don't warrant an out-of-pocket expense on a contingency basis for a return that would make that worthwhile, a lawyer is not going to take that case, even if the malpractice seems to be pretty obvious, because we don't know as lawyers what's obvious. That's why we hire experts to make sure that what we maybe think and feel from our experience may amount to a deviation from the standard of care or negligence in a malpractice case. We want to make sure an expert agrees with us, because we're not going to get up and testify. We can't.
Now, would this matter whether it was a doctor, a nurse, a technician, an anesthesiologist? Are there levels of that make a difference, or is it all under the umbrella of medical malpractice and still time-consuming and costly?
It's all under the same umbrella.
It's all in the same umbrella. The only difference is the standard of care that's applied to the person who committed the malpractice is the standard of care with someone of ordinary prudence with the same training that that person had. So if you're talking about a nurse, she's not held to the standard of a neurosurgeon, she's held to the standard of a nurse.
Is it considered malpractice if someone isn't satisfied with the results of a surgery or a procedure?
No, not always.
Oh,
right.
Again,
because that's
you've got to look at every
issue as well.
situation.
Right. Bad results are common in medical care.
Trying to prove negligence is something else.
Negligence is a bad result, but it has to be the result of a doctor or a nurse or whoever the provider is failing to do something that they should have done. And we hear it a lot. People come in with cases where there's significant injuries, bad results, and you feel your heart goes out to them. Jackie and I have talked to a number of people in those situations. But unless we can get an expert to say with certainty, and it has to be to a reasonable degree of medical certainty, that they deviated from the standard of care, then there's no claim. And even if they did deviate from the standard of care, you have to prove that that deviation caused the injury.
Assuming most people won't know whether or not that issue, whether or not it was actually malpractice or, gee, it just had a terrible outcome, some damage, some injury, but the doctor's not culpable. What should someone do? Should they go to see a lawyer first, right away, to have that clarified before they decide who to take, even if it isn't you or your law firm or someone else's law firm? Should they immediately go to see a lawyer to just evaluate that issue?
Before they have the surgery?
No, she's saying
after there's a surgery, they wouldn't. I assume that we assume most people don't know that if they had a bad outcome, that there would be a reason, of course, to sue for malpractice. So is the antidote to that to go to see a lawyer immediately, just to have them evaluate whether or not there's a case? Is that what has to happen first? What do you do?
Most lawyers will see somebody, no charge, initial consultation, to
point,
review the case. And you review the case. If you think there's something more, that's when the lawyer will say, well, let me get all the medical records. Let's get those sent to an expert for review, and then we'll decide if there's a case. So a lawyer won't tell you when you come in if you have a case, but if he suspects there is, he will take it to that second step.
We've certainly discussed many of the processes about the legal issues, whether it was insurance and various court issues. I think that we're going to need to continue this. And at this point, I'd like to say thank you once again to Jackie Grasso and to David Bazar. We thank them both for providing their experience and expertise. We continue to invite your questions at dbazar@abcglawfirm.com. And knowing that the legal system is so difficult and unwieldy, we really do appreciate your insights, and I think we're going to continue medical malpractice in the coming events, coming issues, and we thank you for watching and hope that you will continue to tune in, be with us on the next session, and please do send us an email of your questions. Thank you. The discussion of legal matters continues.